Can heirs challenge a property sale if a surviving spouse sold land that may have partly belonged to them after an intestate death? Yes, under North Carolina law. The first issue is how the property was titled when the deceased spouse died. If the spouses held the land as tenancy by the entirety, or if the deed created valid survivorship rights, the surviving spouse may have become the sole owner automatically. In that case, the children may not have inherited that land. But if there was no survivorship interest, the children may have inherited an undivided share at death. Then the surviving spouse could usually sell only the spouse's own share, not the children's shares, unless the children signed the deed or there was valid court authority. When someone dies without a will and leaves a spouse and children, the spouse does not always receive all real estate. With one child, the spouse generally receives 1/2. With 2 or more children, the spouse generally receives 1/3. The children receive the rest. Heirs should gather the deed history, death record, estate file, heirship information, closing documents, and any evidence of fraud, coercion, incapacity, or mistake. Possible remedies may include a title ruling, cancellation of a deed as to inherited shares, partition, or an estate proceeding. Timing matters. Fraud or mistake claims often must be brought within 3 years after discovery, and recorded deeds or possession can create defenses. Heirs should have the title reviewed quickly.